first case that come before the court is State of Ohio v. James Genevese. Mr. Meeker will be arguing for the appellant. You will have 15 minutes to present your argument to the court. The arguments are being recorded, so please keep your voice up and remain behind the podium. You should not use the names of children or minors or victims during your argument. You can refer to them by initials or general terms. The judges have read your briefs, both briefs, even though the appellee has waived argument here. And we're ready to proceed when you are.
Thank you, Your Honor. May it please the court, Attorney Blaze Meeker on behalf of Appellant James Genevese. Mr. Genevese presents two assignments of error for the court to consider today regarding his conviction of aggravated menacing, a first-degree misdemeanor out of Barberton Municipal Court. The first assignment is error that the trial court erred in denying Mr. Genevese's motion for judgment of acquittal, violating his due process rights under the 14th Amendment. A Rule 29 motion challenges the sufficiency of the evidence presented by the state. In State v. Jenkins, the inquiry was whether such evidence, if believed, would convince the average mind of the defendant's guilt beyond a reasonable doubt. And that involves an analysis and a review of the evidence presented by the state versus the elements of the charged offense. Mr. Genevese was charged with aggravated menacing in violation of Revised Code 2903-21, which states no person shall knowingly cause another to believe that the offender will cause serious physical harm. That looks to the subjective belief of serious physical harm of the alleged victim here, Mr. Hall. Assuming Mr. Genevese had a gun, because that is a disputed topic here, we contest that there was a gun and there was a second issue, but for the sake of this argument, assuming there was a gun, we don't believe that the state proved beyond a reasonable doubt that Darrell Hall had a subjective belief of physical harm, based on two things. First, Mr. Hall testified that he was more concerned about his son, Darrell Hall. Mr. Hall stated this even though Douglas Hall testified that he had no fear of serious physical harm. He was not afraid under that situation, and the court did grant that motion for judgment of acquittal after the presentation of the state's case. The second reason being that...
Counsel?
Yes?
On that point, when the deputy investigated, didn't the father say that he was fearing for his life?
He did state that, Your Honor. I believe that the testimony that he gave on the day of trial and the statements he made to the officer on the day of the incident are conflicting. He stated on the day of the incident that there was a starter pistol. He believed this would be a starter pistol in a blank round. A starter pistol, of course, can't cause substantial physical harm or death or incapacitation. So I would believe that the starter pistol and the inability to cause serious physical harm conflicts with his statement at trial that he was fearing for his life when that gun was pointed at him.
So the son, Mr. Hall, believed it to be a starter pistol, or that was the father?
That was the father, Your Honor.
Okay. And that's why the case in part was dismissed, was the Rule 29 granted as to father?
No, it was granted in regards to the son, Your Honor. He testified that he had no fear of this incident.
But when the deputy did the investigation at the time of the incident, didn't the deputy ask both of them, the son and the father, whether they feared for their life? And they both responded yes?
I believe so, Your Honor. But I believe, going back to the starter pistol argument, that conflicts with a fear. How can you have a fear of serious harm from a starter pistol that doesn't shoot an actual round? The only other evidence presented by the state was that from the officer, Officer Kensinger, which responded within minutes. He got to the scene, there was no emergency. The only 911 call was made by the Halls, despite there being 50 to 60 patrons at the restaurant on that day. many of these patrons sitting outside on the patio within eye-shot and ear-shot of where this alleged incident happened. Officer Kensinger's testimony at trial demonstrated that he had an apparent bias for Mr. Genovese. He called Mr. Genovese several names as a liar, a hothead, an asshole, a pain in the butt. And despite Officer Kensinger saying that people on that patio would have heard a gunshot, he didn't question or make sure that one of the other deputies questioned one individual on that patio that day. So for these reasons, Your Honor, we believe that the state, that the court here in denying the motion for judgment of acquittal as the sufficiency of the evidence presented by the state did not show beyond a reasonable doubt that Mr. Hall did have this subjective fear. Moving on to the appellant's second assignment of errors in regards to the conviction of aggravated menacing being against the manifest weight of the evidence. Your Honor, this case, well, let me go through the law first. The appellate court assesses the weight of the evidence independently. It doesn't look to sufficiency of the evidence as in the motion for acquittal, but rather the persuasion of the evidence. And the court in State v. Willard looked to a three-step inquiry. First, whether the state's account was believable based on the evidence. And if so, whether it was believable that defendant's version, more believable than defendant's version of the evidence. But if not, whether the state's case was so unbelievable or unpersuasive as to undermine the integrity of the jury's findings of guilt, cause one to question whether justice was done. Well, I believe that that's the case here. The sole evidence presented by the state was the testimony of the two Halls. The testimony of Darrell Hall that the gun was pointed at him and that there was a subjective belief of fear of serious physical harm. We've already been through the evidence of the state. Now let's talk about the evidence that Mr. Genevese put before the court. Mr. Genevese testified that after the first incident, he turned around and walked back up to the restaurant. He testified that there was no second incident. He never left. He never had a gun, and there was no gunshot. Mr. Sachs, one of these 50 to 60 patrons at the restaurant, did overhear the argument. He testified that he was within eye-shot and ear-sight of the argument. It lasted 30 seconds to 1 minute. Mr. Genevese turned around and walked back up to the restaurant. He never saw Mr. Genevese go back to the Hall's area. He never saw any more argument. The next thing he knew, Mr. Genevese was in a sheriff's cruiser. Mr. Moore, who was also working at the marina, testified that he was 80 yards away. When he was returning back towards the dock area, he saw both the Halls on their boat arguing with each other. He testified that he never heard a gunshot. He never saw Mr. Genevese with a gun. He's never known Mr. Genevese to ever have a gun. So I believe that's more evidence that there wasn't a second incident. Thirdly, I think the biased investigation of the Sheriff's Department here is further evidence that there was no second incident. The crime scene unit came to the scene. They searched with metal detectors. They dug up the ground. They never found any bullet. They never found the gun, the alleged gun. Despite these people being seated outside the restaurant, they didn't question one of them. And one of the other sheriff deputies on scene states that she didn't see the point that Mr. Genevese, questioning the people inside the restaurant because Mr. Genevese had already colluded with them. She made that statement without any proof at all. And by doing so, they left out many witnesses, including Mr. Sachs. The Hall's accusation, without any other corroborating evidence, is not enough.
Counsel,
Yes.
on that point that you just raised about the deputy saying that he had already colluded with them,
Yes.
was that presented at the trial?
It was, Your Honor. It was part of the body-worn camera of the officer, and it was caught on that camera.
Okay, so there was additional evidence that besides the two, the testimony of the son and the father, there was also the body camera testimony?
There was, Your Honor.
And also, was there the testimony of the deputy then?
There was.
as well?
And the deputy acknowledged that he made these statements about Mr. Genovese. The statements can be heard on the recording. And one of the extraordinary statements made by Officer Kensinger is that he told the Halls that unless we get more evidence, there's nothing we can do. Well, his bias led Deputy Kensinger to seek these charges, even though he told the Halls he didn't have enough evidence. On the other hand, Mr. Genovese has demonstrated sufficient evidence to show a reasonable doubt that there was no second incident, that there was no gun, no gunshot. There's no other witnesses besides those presented by Mr. Genovese that this second incident ever occurred.
You have, I'm sorry, our situation isn't working over there, so you have about 4.5 minutes left, so.
Your Honor, I will also point out that the state cited a case, State v. Schumacher. In that case, the individual was shaking, was very scared, and that individual was not presented at the trial in that case. And the court found a substantial fear in that case, but in this instance, we don't have any of that. Mr. Darrell Hall never moved, he never ran away, he never flinched, he never said that he retreated. The only person that did retreat was Mr. Genovese. After the first incident, he went back into the Ramp restaurant and never came back out. I believe the only thing that, as far as their composure that day, is Officer Kensinger stated that they were slightly agitated. But there was certainly no testimony on the day of the incident that they were frightened, they were upset. Darrell Hall testified that he was more set back. He said, calm down, calm down. But he never retreated. He never thought that he should get out of the area due to this situation involving an alleged gun. I believe that the evidence presented by Mr. Sachs and Mr. Moore is considerable. It sets the scene that this was not a long, drawn-out incident. It lasted 30 seconds to a minute. Nobody on scene besides the Halls the state hasn't presented any evidence that the Halls, besides anybody that the Halls heard a gunshot or saw a gun that day. It's undisputed that this first incident occurred. We don't contest that. There was a heated argument between the two regarding the repair of the boat. That led to Mr. Genovese being threatened by these individuals, and Mr. Genovese did what he should have done. He retreated. We believe that the evidence set forth establishes that the Halls did not prove beyond a reasonable doubt that Mr. Genovese committed the offense of aggravated menacing. That's all I have, Your Honor. If there are any more questions.
Are there any questions? Hearing none, we thank you so very much for your for your argument. The court will take it under advisement. We will issue a decision in due course, and the clerk of courts will mail a copy of that decision to you on the day that it is released. And the